Good morning to all distinguished participants, faculty members, researchers, innovators, and professionals. I am delighted to welcome you to day one of 5-day faculty development program on patent filing in India. Today's session is titled Comprehensive Coverage of Patent Law in India Overview. The objective of today's session is to develop a strong conceptual foundation in Indian patent law, understand its evolution, examine the major provisions governing patents, identify patentable and non-patentable subject matter, understand patent rights and infringement, and finally obtain an introductory understanding of the patent filing process. Let us begin our today's session roadmap. Our discussion will cover 5 major areas. First, we will examine the evolution of patent law in India. Second, we will understand the important features of the Patents Act 1970. Third, we will discuss patentable subject matter and important exceptions to patentability. Fourth, we will examine the patent rights, obligations, and infringement. Finally, we will have an introductory discussion on patent filing process, taking us from the initial idea towards patent grant. These 5 areas will provide participants with a structured understanding of the Indian patent ecosystem. Before discussing the legal framework, it is important to understand why patent law matters very much. Patent transform innovative ideas into protected and potentially exploitable intellectual assets. First, the patents reward innovation. They provide inventors with exclusive rights and thereby create an incentive for research, development, experimentation, and creative problem solving. Second, a patent provides legal protection against unauthorized use, manufacture, or sale of a patented invention. Third, the patents contribute to economic growth by encouraging technology transfer, investment, commercialization, and industrial development. Finally, there is an important balance between private rights and public knowledge. In return for patent protection, the invention is disclosed to the public. This disclosure contributes to the wider technological knowledge base. Therefore, patent law attempts to maintain a balance between protecting innovation and serving the broader public interest. Let us now look at the historical evolution of patent law in India. The development of Indian patent legislation can be traced back to 1856, when Act 6 represented India's early patent legislation and was modeled on the British patent system. In 1911, the Indian Patents and Designs Act consolidated earlier legislation into a unified framework dealing with patents and designs. A major transformation occurred with the Patent Acts of 1970. This became a landmark legislation and initially focused significantly on process patents, particularly in the areas such as food, drugs, and chemicals. The act came into force in 1972. Subsequently, India undertook amendments during 1999, 2002, and 2005 to comply with TRIPS framework and to introduce product patents in relevant sectors. From 2016 onwards, the Indian patent system has continued to modernize, including initiatives relating to faster examination, benefits for startups, and digital filing. Understanding this historical development is essential because it helps us appreciate how India's patent system has evolved in response to technological, economic, and international developments. Now let us examine the Patents Act 1970, which serves as the principal legislation governing the grant and regulation of patents in India. One important feature is the 20-year patent term calculated from the date of filing. The post 2005 framework provides for both product and process patents, including in areas such as pharmaceuticals, food, and chemicals. Another important aspect is the working requirement, under which patentees are required to provide statements concerning the commercial working of their patents through prescribed mechanism. The Act also contains provisions relating to compulsory licensing, particularly to ensure that patented inventions can be made accessible where public interest consideration arise. The patent system follows a structured process involving filing, publication, examination, and opposition. The administration of the patent system is undertaken through the Office of Controller General of Patents, Designs and Trademarks under the Patent Office framework. Together, these provisions establish the legal and administrative foundation of India's patent system. Let us now come to one of the most important questions. What can actually be patented? Under Section 2 of 1, an invention must satisfy the following three essential criteria. The first criterion is novelty. The invention must be new and must not have been disclosed in prior art anywhere in the world before the relevant filing date. The second criterion is inventive step. The invention must involve a technical advance or economic significance and must not be obvious to a person skilled in the relevant field. The third criterion is industrial applicability. Invention must be capable of being made or used in an industry. Therefore, participants should remember a very important principle. Novelty, inventive step, and industrial applicability must be considered together. An invention must clear all three fundamental requirements to qualify for patent protection. Having understood what may qualify for patent protection, let us now consider the important exceptions to patentability. Under Section 3 and 4 of the Patents Act, identify certain categories that are excluded from patent protection. These include inventions that are contrary to natural laws, discoveries of scientific principles and abstract theories, and certain discoveries involving new forms of known substances. The Act also excludes business methods, mathematical models, and algorithms within the specified statutory framework. Literary, dramatic, musical, and artistic works are also outside the patent system. Similarly, certain schemes or methods for playing games, traditional knowledge, and certain aggregations of known properties, methods of agriculture, and inventions relating to atomic energy are excluded. This slide also highlights plant and animal varieties subject to the applicable statutory treatment of microorganisms. A particular important provision is Section 3 of D, which has been central to Indian pharmaceutical patent law. Therefore, when evaluating an invention, it is not sufficient merely to establish novelty. We must also carefully examine whether the invention falls within any statutory exclusion or not. Let us now understand the rights and obligations associated with a granted patent. A patentee has important exclusive rights relating to the patented invention, including the right to make, use, sell, or import the patented invention subject to the applicable legal framework. A patent can also be assigned, licensed, or transferred. Where infringement occurs, the patentee may pursue appropriate legal remedies and claim damages as provided under law. The patentee may also surrender the patent or seek amendment of the specification in accordance with applicable provisions. However, patent rights are accompanied by important obligations. The inventions must be fully and clearly disclosed in the specification. The required renewal fees must be paid periodically to maintain the patent in force. The patentee must also comply with requirements concerning statements of commercial working, including Form 27. These provisions demonstrate that a patent is not simply a monopoly right, it is a legal framework in which rights are balanced with responsibilities and public interest considerations. Now, let us understand the concept of patent infringement. In simple terms, infringement involves unauthorized making, using, selling, or importing of a patented invention without the consent of the patentee, subject to the specific provisions of patent law. The presentation identifies direct infringement, which involves activities such as making, using, or selling the patented invention without authorization. It also introduces indirect or contributory infringement involving situations where a key component is knowingly supplied for an infringing product. Where infringement is established, several remedies may be available. These include temporary or permanent injunctions, damages or an account of profits, and in appropriate cases, or destruction of infringing goods. At the same time, the law provides defenses under Section 107, allows certain challenges to patent validity to be raised as defenses in an infringement proceeding, including ground reality to novelty, obviousness, and patentability. Therefore, understanding both patent rights and the limitations and defenses associated with those rights is essential. We now arrive at the final major topic for day one, an introduction to the patent filing process. Patent filing can be viewed as a structured journey from an innovative idea towards legal protection. The first important stage is prior art searching. Before filing a patent, it is important to investigate existing patent and technical literature and assess the novelty of the invention. The second stage is drafting the specification. Depending upon the circumstances, an applicant may proceed with a provisional specification or a complete specification. The third stage is filing the application with the Indian Patent Office using the prescribed requirements, including Form 1. The application is then published generally after the prescribed period. Following publication, the application proceeds towards examination, including the request for examination and response to objections raised by the patent office. Finally, where the legal requirements are satisfied, the patent is granted and published in the patent journal. This is just only an introductory overview. The detailed aspects of each stage can be examined progressively during the subsequent FDP sessions in the following days. This faculty development program is particularly relevant to faculty members and researchers, postgraduate and PhD scholars, innovators and startup founders, and members of IPR cells and academic administrators. Participants are expected to develop a better understanding of the fundamentals of patent law. This will gain greater clarity regarding patent rights and the patent process, develop awareness of the intellectual property strategy, and understand the importance of obtaining appropriate legal protection for innovations. The program also provides an opportunity to connect academic research and innovation with the broader intellectual property ecosystem. Let us summarize the major learning points from day one. The Indian patent law has evolved considerably from the early legislation of 1856 to the comprehensive framework established by the Patents Act 1970 and its subsequent development in the context of TRIPS compliance. Second, an invention seeking patent protection must satisfy the fundamental requirements of novelty, inventive step, and industrial applicability, while also avoiding the statutory exclusions under sections 3 and 4. Third, patentees enjoy significant exclusive rights, but these rights are accompanied by obligations such as adequate disclosure, payment of renewal fees, and compliance with working statement requirements. Fourth, patent infringement can lead to remedies such as injunctions and damages, while the law also recognizes statutory defenses. Finally, the patent filing journey can broadly be understood as search, draft, file, publish, examine, and grant. These concepts provide the foundation for our deeper exploration of patent filing and intellectual property protection in the sessions ahead. Ladies and gentlemen, with this, we conclude day one of our faculty development program on patent filing in India. I hope today's session has provided you with a clear and structured understanding of the Indian patent system, its historical development, key legal provisions, patentability requirements, exclusions, rights and obligations, infringement, and the basic patent filing journey. I sincerely thank all the participants for your valuable presence and active engagement throughout the session. Thank you very much for your participation. I look forward to continuing this learning journey with you in the upcoming sessions. Thank you and wishing you a productive and enriching faculty development program in the coming weeks.